Thank you, Barry. Good morning. I have finally come to the conclusion that I'm probably certifiably nuts. Obviously, that doesn't come as a big shock to those of you who have cases with me, but think about it for just a minute. Who in their right mind would want to get up here and do a presentation at the Family Law Institute? Initially, you spend all kinds of time reading the cases, reading the rules, looking through a bunch of materials, analyzing your thoughts, and setting out your written presentation. That's just so you can come here so that 200 to 300 wordsmiths can analyze every word and every sentence that you've written. Then you come and you decide, okay, I'm going to present the same materials or something in addition to it to a bunch of professional orators and advocates that are already here. Then you not only like pain enough that you want to write it and present it, but you then expect to be graded on it, just like when we were in law school, which I personally would never want to go back to. And finally, you do all of this for free. Absolutely nothing. So, you see, you have to be nuts to do this. Today, our presentation is on Rule 69. At least that's what I'm going to be talking about while you're emailing and writing back to your offices and your staffs and your clients in the audience and talking about the cases that you're currently working with. The materials are in the book starting on page 280 and they go to page 299. In the materials, there's an overview of Rule 69, which we'll talk about in depth. There are a summary of some selected cases. I think there's 9 or 10 of them in there. I simply summarized them to make it easier for you so you don't have to go read the opinions if you want to know what they have to say. So we'll begin with the history of Rule 69. In your materials, there's a copy of the old rule and how it was stricken and the new rule that's set forth. Of course, it stems from the original Rule 80D in the Arizona Rules of Civil Procedure. And the case law says that you can use Rule 80D in order to interpret Rule 69. So you can use those civil cases that you all knew back in the day to help understand it. The rule was originally adopted on January 1, 2006 when our family law rules came into place. So it's now been enforced for 9 years. And then it was amended again in 2011, primarily because the original language of the rule was so meager that it had to have some changes. So now we have the current version, which has the 3 methods of finding a Rule 69 agreement. It has presumptions, it has burden of proof, it has the 317 language, and some attorney's fees discussion in there as well. That was all added. I am not personally aware of any amendments that are proposed to Rule 69, but after doing the homework that's necessary for this presentation, I'm not so sure that that isn't a good exercise that might be undertaken in the future. The scope of the rule applies to all agreements. Rule 1 of the Rules of Family Law Procedure states that all agreements includes everything under Title 25, all family law cases. So you can just trigger off and enumerate all of those in your mind. Everything from pre-decree to post-decree to enforcement actions to UCCJEA to UIFSA to everything else is included within the scope of what's in Title 25. Of course, Title 25 doesn't include orders of protection, injunctions against harassment, Title 8 cases, or any of those things. But the point is there anyone here who doesn't use Rule 69 almost every day? At some point in your practice, you almost run into it every day. It's probably the most comprehensive rule that we use. And yet we have no citable case law under the rule that we can refer to. The 2 cases that actually referenced it were the Doyle case, which I've summarized, a memo decision. We can't cite it, although, I don't know if it's been mentioned previously, but as of January 1, 2015, any opinions or memo decisions that come out now are allowed to be cited. So the rule will change for the future, it just won't change for the past. And the Reader case, which Barry's already mentioned, has been depublished. So we don't have any of those. Yet we use it frequently and need to understand it. I want to take the rule apart a little bit so that we follow what it does and what it doesn't do. And in doing so, I'm going to suggest that you think about what does the rule do internally, and what does it do externally when we cross-reference it with other rules and statutes that we use frequently? As we all know, there are three methods by which we can have an agreement. One is in writing, one is on the record, and one is an audio recording. The last two of which you have to do in front of an authorized person under the second one, and the third one is you have to do it before a Rule 67 mediator or settlement conference officer. A written agreement, or an agreement in writing, is the way the rule is worded. It does not say it must be signed. It can be between lawyers, it can be a series of letters, and I've given you the case law that cites how it can be done. I suggest you cross-reference it with Rule 67 of the Rules of Family Law Procedure, Sections B and D, because under that rule it states that binding agreements in private mediation and settlement conferences not only have to comply with Rule 69, but they also have to show they're voluntary, full disclosure, they're binding, fair and equitable, and in the best interests of children if the case has children. I also suggest you cross-reference it with local rule, this is Maricopa County only, 6.5E, which states that agreements reached in open negotiations also an agreement has to be signed by the parties. That's the only place it's referenced that it has to be signed. An agreement on the record is one that's done by a person authorized. I called our presiding judge as well as one of the JAs I know well and asked them if they have a script that they use, and they said yes, as they do for most things. And in the materials I've given you the typical Maricopa County Rule 69 agreement language, which is the script that the judges have been supplied with for use on a Rule 69 agreement, and it's in the materials. You'll notice that you have to hear the agreement, you have to understand it, it has to be the full agreement. If you have a lawyer, you had his or her advice. It's voluntary, not coerced. Fair and reasonable, notice the word equitable wasn't used in the script, that it's in the best interest of children and it can be enforced as a court order. It does not state that there has to be full disclosure in the script. And if you're like me, when you go to court, I think every judge that I appear in front of that accepts a Rule 69 agreement has their own language that they either add to or detract from this script every time they use it. So if there's not full disclosure, and you know from Breitbart and Knapp that full disclosure can be one of those reasons to set aside a Rule 69 agreement, we might want to consider adding that into the language when we are rehearsing a Rule 69 agreement. I'm not going to spend a whole lot of time on Barry's cases. Reader was depublished. The John's case I've summarized in the material. It has to be before a person authorized. I raised the question, can a person or can lawyers agree to elevate a person to the level of a judge pro tem on their particular case if that person is serving as a judge pro tem in general? Answer, no, you cannot. An audio recording can be made in front of a settlement conference officer appointed by the court. I've raised some questions about that, and we'll talk about it in a little more detail when we go through some slides. I want to focus on a few of the concepts that are under Rule 69, though, that need to be addressed. One is the presumption of validity and the burden of proof. You'll notice under Rule 69, the burden is on the party challenging the agreement. There's nothing stated with regard to what is the burden of proof that one must show in order to set it aside. So we presume that it's going to be a preponderance of the evidence. Rule 69 also incorporates by reference Section 25317, which is the separation agreement section of the statutes, as you recall. In other words, the pre-decree separation. We usually call it a property settlement agreement. The standard under 25317, under the Sharp case, is that the party who is moving to promote the agreement or accept the agreement bears the burden, and they must prove it by clear and convincing evidence. So there's a difference between the standard to be used if you're challenging the agreement as opposed to if you're trying to enforce the agreement, at least as the current state of the law is characterized. There's no method or time for how one challenges a Rule 69 agreement. You have to resort to other authorities. Usually you'd use Rule 85C to set it aside like you would on any other judgment. There's nothing mentioned about a right of rescission under a Rule 69 agreement either. However, it's implied when it talks about that a party has a right to challenge it, and it also states what they have to do in order to presume it and the burden. Next section I want to talk about is the language that says in order to set a Rule 69 agreement aside, you have to prove a defect in the agreement. Now, I don't know about you, but I have no idea what a defect in a written agreement might be. I did tort work and jury trials, strict liability cases for about the first 12 to 15 years of my practice. And we talked about defects in products liability cases all the time. You can have defects in design, you can have defects in manufacturing, you can have defects even in language of labels or instructions or warnings on products. But I don't know that anybody has ever defined what a defect is in a contract. And in this particular case, there is no guidance. So you have a free-for-all when you're challenging the agreement to decide what it is you're going to claim as the defect. I assume that it's going to be contractual defenses, which I've enumerated in the materials. Equitable defenses are also stated there. And typical contract defenses would certainly be something that should cross one's mind if they're going to challenge the agreement. The last section I want to talk about of 25.317 has to do with the court's right to review a Rule 69 agreement for independent discretion under 25.317. There's no reference to which portion of the statute that the court is directed to refer to. You notice also in Rule 67 that it allows private mediators to approve Rule 69 agreements and make findings under 25.317. They can make jurisdictional findings. They can also even sign a decree. They have to make a finding, as we all do in Rule 69 agreements, that the division of assets and debts and other aspects of the agreement are fair and equitable. So you have to prove, if you're going to set it aside or confirm it, it's fair or that it's unfair. So I suggest and ask you, what does fair mean? We know it's not equal. How far from equal is still fair? Party statements in an agreement are not enough. You can say it all you want or have your clients write it, but that doesn't do it because the case law already says that the parties' voluntary statements do not make it fair and equitable. So I suggest maybe one of the practice tips that we could use from this analysis is when you are writing your agreements and designating them as fair and equitable, maybe we state why they're fair and why they're equitable. Last section is does fairness apply in a pre-decree agreement and in a post-decree agreement? Remember, Rule 69 covers agreements. It doesn't designate pre-decree or post-decree. 25.317, which is incorporated in Rule 69, discusses separation agreements. So a legal question arises is, does Rule 69 apply to both? And do all of our agreements, even post-decree agreements, have to be analyzed and subject to judicial scrutiny for fairness and equity? Or are they simply contracts and we're allowed to make them binding without any judicial supervision? A further question arises, if the court does decide to review your Rule 69 agreement, can they sever it? If there's a defect, does it apply to the entire agreement and therefore it's void, or do you have the right to sever the clauses so that you can find the defective portion and eliminate it from the rest? And does your severability clause that you put in your property settlement agreement actually apply? Can the court disregard it as well? Okay. Hopefully I've created enough questions about Rule 69. We can talk about it. In your materials, I've put 6 scenarios. These are typical examples that either I've had in my cases or I've seen you have in your cases at somewhere along the way, and I'm sure that just about everybody's had them in there. So let's, in light of the principles that we just went through, talk about what they are. Scenario number 1. H and W bullet point the terms of a settlement agreement on a napkin while they're meeting at a local restaurant for dinner. Okay? Is it a Rule 69 agreement? Maybe. It's definitely a writing. It doesn't have to be signed, so it qualifies for the first criteria. What will make it a valid agreement, or what will make it not? Terms and conditions have to be sufficiently clear and complete in order for it to be a Rule 69 agreement. Otherwise, it would fail. Second, both parties and their lawyers reach an oral agreement at a four-way settlement conference in one of the lawyer's offices. However, the hour is late, and they have to leave before the agreement gets put into writing. One lawyer dictates the agreement into his handheld device. Is it a Rule 69 agreement? No. Right. It's oral, so it's not a Rule 69 agreement. It's not before a mediator or a settlement conference officer appointed by the court. Can you make it one? What about transcribing the oral dictation and exchanging it and Bill signing it? Right. That's how you could probably make it into a valid Rule 69 agreement. Scenario number 3. It's the Sunday night before trial the next morning. Counsel for both parties have been negotiating all weekend and finally reach an agreement over the telephone. Is it a Rule 69 agreement? No, it's oral. How do you make it one? Show up the next morning at your trial and put it on the record, right? That's the typical way we would do it. When I had this case, that's what I had to do. You could type it up if somebody wants to stay up all night and put it in writing and try and exchange it back and forth and sign it and see if that would constitute a Rule 69 agreement. But there's a very big caution here. What's the caution? One of these parties might change their mind when they get up the next morning, right? So, you better be ready for trial. Scenario 4. Two busy counsel wait to start settling the case until the day before trial. Never heard of that, have you? They believe they have an agreement on all major terms, and they file their notice of settlement with the court to vacate the trial. Whoops, then the agreement falls apart. Is it a Rule 69 agreement? No. A notice of settlement. Why isn't a notice of settlement a valid agreement? No terms, no conditions. It doesn't have all of the complete data that it needs. So the court can't accept it as that. Case is Lyons Enterprises, Inc. v. Custer, 168 Arizona 439, 814 P. 2nd, 780, App 1991. Civil case, notice of settlement, not a valid agreement. So, I'll bet just about everybody in this room has had this happen somewhere along the way. So you're going to, first of all, eat a lot of crow when you go into Judge McMurdy's court or Judge Thompson's court or somebody else and tell them that you no longer have a Rule 69 agreement that you thought you had, right? You've made a representation to the court which turned out to be false. So, it's time to quickly get a Rule 69 agreement if you can. Otherwise, you're going to be litigating your case in front of a judicial officer that's not going to be really very happy. Scenario number 5. A crying mother comes into your office having signed a consent decree and a parenting plan which has already been lodged with the court for signature. She no longer agrees with the terms and conditions and wants you to get out of the agreement. Is it a Rule 69 agreement? Probably so. What's your first step? If you're representing this person, Keith?
Object to it so you get a sharp hearing.
Correct. Let him
Can you repeat it?
You need a really big retainer.
Can you repeat it for the camera, please?
That's right. Keith says that you want to file and ask for a hearing. First thing you got to do is notify the court you don't agree with the agreement and sign a rejection from your client and then ask for a sharp hearing. And Doug said,
You need a really big retainer.
Get a big retainer right up front. Yes, that's for darn sure. And then her burden will be to prove the defect in the agreement. 25.317 applies because it's a pre-decree agreement. But it raises an interesting question. I had this very case happen. And we did set it aside and ended up doing new documents. But is there a right of rescission for people in family law? Or should there be a right of rescission for people in family law? And it's not heresy for me to ask that question, because the contract lawyers are going to all tell me, no, we make binding agreements. They should be bound by what they sign. Yes, Judy.
Let me add a little spin to this. What about the agreement that the client signs in the parenting conference without the lawyer's presence? What about the agreement that they sign in the parenting conference with the private provider that they have to sign after he takes their cell phones away from them and says that they can't call their lawyers?
Yeah.
In the parenting conference.
Yeah.
And then they try to, and then they want to get out of it.
Well, you're raising the same question I am, and that has to do with whether or not there should be or is a right of rescission. Rule 69 suggests that sometimes we can do those. We have some other thoughts? Yes.
We're putting in all of our private mediation that Rule 68 applies, even though it's not through conciliation court, so we have the ability to revoke. Because we keep running into that problem. And
who is we?
I think most of us in Flagstaff, right, guys?
Okay, Coconino County. Okay, one more comment.
I think you asked the question whether there's a right to rescission under this fact pattern. And, you can certainly argue the contractual defenses based on the fact pattern if this crying mother was under duress or there was some information that she was not privy to or was not aware of, when she signed this agreement. I think you can certainly look to the contractual defenses to get out of this agreement.
You raise the contractual defenses as a defect to the contract, correct. That's exactly how you would do it, and that's how it was done in this particular case. But I just say, don't be so quick to judge as to whether we have contracts or whether we don't, because in conciliation services, both parties have a right to object even after 30 days, up to 30 days if I think it's correct, after they've made an agreement, if their lawyers weren't present. I did a refi on my house this past month, and I had a right to rescind the whole contract after I did it for, I think it was 48 or 72 hours. When we have PC recommendations that are made from parenting conference settings, then they're subjected, if they're sent to the court initially adopts them and gives you a right to rescind thereafter or at least request a hearing. So maybe we need to think more about why families are different than other contracting parties. Why husbands and wives who've lived together maybe need to have a little time to make sure that the agreements they enter into are correct. Last scenario. Annette, how much time have I got? Okay. Plenty of time. Great, thanks. All right. After trial and the decree is entered, while an appeal is pending, H and W sign a settlement agreement. The agreement was prepared by H's counsel but never seen by W's counsel. Thereafter, W uses that as an excuse and challenges the agreement. First question. Is it a Rule 69 agreement? Keith, you're shaking your head. Probably so. Now comes the tough part. Does the trial court have the right or obligation to review this post-decree agreement for fairness under Sharp and 25.317? No? Why? Court has no jurisdiction because? Okay. Assume the appeal has been dismissed when the settlement agreement was signed. Sorry. Okay? Well, we'll find out the answer to this question one of these days, maybe. If it does have the right to review the agreement under 25.317, even though it's a post-decree agreement, then who has the burden of proof? And what's the standard? That raises the question we talked about before. Party accepting the agreement, party challenging the agreement. Clear and convincing, preponderance. We don't know the answers to those questions. But we will probably find out with either one of you litigating that question or one of us litigating that question pretty soon. Those are the end of the scenarios that I thought would be interesting for us to address under Rule 69 because they're common and ones we use every day. My conclusion is this: Rule 69 is used an awful lot. There is much more to Rule 69 than we think when we look at it at first blush. Probably there needs to be some tweaking and modifications and clarifications of the rule in order to use it going forward. But if your goal is to really help your clients to make enforceable agreements and to do it amicably to avoid a trial, then we need to understand how we can do that and make sure that they're binding on them, and we better know the rule very well. Thank you.